your pay stubs, I got two of them. Where'd the other one go? Okay. All right, I am about to share a pay stub, Your Honor. Let me check and make sure there is no sensitive data on this. Okay. All right, Mr. Coote, now you and Mr. Mahoney went through and tried to do some math on your annual income. Isn't that correct?
Yes.
Okay. So at the end of last year, you were making $51.92, 0.9231 cents per hour. Is that correct?
Yes.
That was your base. Yes?
Yes. Sorry.
Okay.
Yeah.
And so Mr. Mahoney calculated that if you took that $51.9.9231 and you multiplied that by 80 hours and then by 26 pay periods, you made a lot more money than you actually made last year, didn't you?
Yes. Yes.
And so would it be fair for your obligations to be calculated based on money you didn't make?
No.
Now, your most recent pay stub, who calls you every year to tell you that you've gotten a raise?
Mike Chambers.
Did that person call you this year?
No, because he left the company.
And so were you even aware that you had a pay raise?
No, I was not.
If you had known, would you have told the court yesterday or
Yes.
Monday, Tuesday?
Yes.
Okay. Now, taking your year-to-date on your sixth paycheck of $45,000, I've got this stupid thing and I don't know how to make it go. There we go. $45,172.49. And you said that in your financial information statement, you multiplied that out by 26 pay periods and divided by 12. Is that correct?
Yes. Yes.
Do you believe that that is a far more fair and accurate representation of your income?
Yes.
Far more fair and accurate than Mr. Mahoney's numbers?
Yes.
And the child support calculation that your lawyer messed up, that would be me. Do you think that despite the mistake of only including one child, that the judge is incapable of using your gross income and calculating 30%?
No, I don't think he's incapable of it.
Do you think that he's incapable of taking the net income of, or sorry, your net income and Natalie's net income and calculating the 30% of whichever one he thinks is appropriate?
Yes, I believe he's capable.
Okay. And just for clarification purposes, if you take your pay rate of last year and subtract it from the pay rate this year, it's actually only an increase of $1.44. Is that correct?
Yes, that's why I was hesitant to say the $2.
Are you asking the court to calculate based off of your government issue W-2 rather than Mr. Mahoney's math?
Yes, please.
And to remind the court of a comparison, what did you make for your bonus in 2019?
Total, I made close to 60,000 with all bonuses said and done, I believe.
And
well, no,
let's clarify for the court a little bit more as to why you didn't receive that kind of bonuses this year. What happened that you did not receive that level of bonuses?
Well, once again, COVID hit. So materials, supplies, things like that, delayed jobs. When you don't get that kind of bonuses because you don't finish early and you don't finish on time or within budget, things like that. And so number one, we're over budget. Lumber prices literally doubled. Nobody could hold to those prices anymore because of COVID and shipping. We got multiple months behind because everything was coming from China and that was all halted. So It's not, it's like I tried to explain a few times, bonuses aren't guaranteed. They can fluctuate dramatically.
And as far as the increase, you said the increase in lumber, are you seeing that the lumber prices are decreasing as shipping is improving?
No, no.
Have they
they're not.
stayed the same?
Yes.
What, if any, anticipation do you have of your bonuses increasing for the coming year?
I don't anticipate it. Not until we're out of this market.
Do you have any idea when that might be?
No clue. No.
And do you think it's a reasonable snapshot of your parenting to look at something that happens for 8 months, 4.5 years ago?
No.
And what evidence did you see Natalie present that you were absent?
Zero.
And what evidence did you see her produce regarding call logs that the kids did not talk to her in your possession?
Zero.
Who has the login information for the kids' Google Hangouts accounts?
Natalie does. They were accounts that I created, but she kicked me off of them and changed everything.
So, and those Google Hangout accounts are what are used to access the tablets, correct?
That and other multiple, just different types of accounts within there. Yes.
And
It's their
so
Google sign-on accounts, which covers Hangouts.
even if you wanted to get onto the kids' tablets to provide the call logs, are they in your possession today?
No.
And if you wanted to get onto the Google Hangouts to produce the call logs, would you be able to do that?
No.
How does it make you feel about the lack of communication between the two of you, especially about things like therapy?
It's extremely frustrating. It's pointless. Mr. Mahoney and I went over one therapy session for almost, I felt like an hour, over something that could have been so easy. It's not. It doesn't have to be
Explain.
like
So easy. So easy how?
open communication
Between you and whom?
between me and Natalie, just back and forth.
So
Simple.
how could it have been handled more easily rather than how it was handled?
Open communication, emails, response to my email, especially when I emailed about the therapy at the beginning of July to her. There was zero response.
Now, you mentioned that we had a hearing set the morning after MLK Day. Is that correct?
Yes.
Did you think that it was a fair offer for you to have extra time so that you would have to drive an hour to take the kids to school before you came back for a hearing?
No.
Prior to last month, did you even have any intention of moving to Austin?
No.
Do you even want to move to Austin?
No, it means I have to move everything. I mean,
But what the reason you're doing it is, or considering it, is why?
because that's my livelihood to pay for my family and to support my family.
And who's going to pay for this bankruptcy if you don't have any income?
That's a great question. I don't know.
You heard Miss Koo say that she spent between $2,000 and $3,000 for your son's birthday, the trip. You heard that correct?
Yes, ma'am.
You think it's fair that you're being asked why you spent money on the mortgage, but no one's asking her why she didn't use that money to pay down community debts?
No, that's not fair.
And let's just I'm sorry, Your Honor, it's going to feel a little bit like beating a horse, but I just want to make sure it's all very clear on the pay stubs. This is 38. I don't know what I'm sharing, so I'm going to stop.
You did that on purpose. You wanted us to see your baby.
You didn't want
Oh, is that what y'all saw? Sorry, guys. Okay, let's just go through. Is this the right one? No, this is your bonus. Okay, that's not the right pay stub. So this looks like a right pay stub. So, all right, so the pay date from 3/5. So you get an auto allowance of $225. Is that correct?
Yes.
Can you see this?
Yes.
Okay. And device reimbursement of $75.
Yes.
Okay. And in this case, you had a holiday pay, but generally your regular pay would be 80 hours times the 53.3654.
Yes.
Okay. And then you get your rent discount, which is $457.50.
Yes.
And if you add all of those things up, it equals $5,026.73 on your current gross. Is that correct?
Yes.
So there is no reason to calculate or count any of those twice.
No.
There's no reason to count additional income for your rent discount or for your car reimbursement allowance. None of that, correct?
Correct. Yes.
Now, you get a bonus for finishing jobs early. That's what you said earlier, right?
Yes.
And you're about to finish the Sienna project. Is that correct?
Yes.
How far ahead or behind are you on the Sienna project?
But we are behind, so I will not get the early bonus finish.
How much behind are you?
About 2 months right now.
Okay. I'm going to stop sharing. What information did you see Natalie provide with regard to her future earnings?
0.
What information did you see Natalie provide with regard to her future job prospects?
0.
If you were both able to move to Austin, would you encourage it?
Yes.
Pass the witness, Your Honor.
Judge, just a few. Sir, I asked you to bring some evidence, some exhibits, right? Before the break.
Yes.
Remember that?
Yes.
And you honored my request, and you brought us I think it was respondents. Was it 51 or 52? Which one was the text message from Natalie when she's at the hotel?
53.
You remember? Sorry?
53.
Okay. I want to make sure we. So you brought the evidence to show. I'm gonna show you respondents 53, and you brought this evidence to show the court that she was drinking and driving with your children. Is that right?
Yes.
Sir, could you show me in that message where it says she was drinking and driving with the kids?
We are pretty far out, and I drank a little, so we are getting a hotel for the night.
Okay. My phone is fixing to die, and I'm going to see if the hotel has a charger. Is that right?
You asked me to show you the part where she said drinking and driving, but yes.
Sir, where does that say she's driving anywhere?
Are they walking to a hotel? Or
Sir, does that say that she's drank too much and the kids are in danger?
no, it does not say that specifically.
In fact, it says that she's only drank a little, doesn't it?
To me, in my opinion, drinking a little is
Objection, non-responsive.
Same.
Sir, does it say she's only drank a little?
yes.
Okay. And sir, I'm going to show you what I've marked for identification as petitioners. Oh, let me do it this way.
Matt, Mr. Mahoney, you're still sharing your screen.
Oh, I'm sorry. Thank you. At least I didn't put that picture up like you did.
I'm just showing off.
I know that was not fair. Now, sir, I'm going to show you petitioners 31. And that, Ms. Lefevre, I sent this one to you over this morning. It's your application for protective order. The judge has already taken judicial notice of the file, I believe. I think it has the same cause number, so it's in the same file.
You said it's labeled what?
P31.
Do I have a P31? I don't have a P31. I go 29 and then I skip to 33, 44, and then I skip to 37.
I will fix that for you right now. You got it? Should be in your email.
Okay, I see it. However, it's not the same cause number, and I believe that's been non-suited.
It had, well, I don't know whether or not it was non-suited, but you want me to get him to identify it?
I'm just not sure what the relevance is right now.
I understand. Judge, and I,
That's the only objection. Just if you want to offer it, and we'll take the objection up.
yeah, Judge, I would offer P31, which is the application for protective order that also includes the sworn affidavit of Mr. Q attached to the end.
Ms. Lefevre?
I'm sorry, I heard some of that. Mr. Mahoney had crackling through the middle of it.
Oh,
You're offering it what?
P31, it's the application for protective order, but also includes Exhibit 1, which is attached to it, which is applicant's supporting affidavit of Mr. Q.
Scroll down to the bottom. Okay. I have no objection.
P31's admitted.
Sir, do you remember in your application for protective order what you swore to the court about that text message that you got from Miss Q?
No, I do not remember.
Sir, do you agree with me that if you told the court that you have a text message from her where she admits to drinking too much?
Objection mischaracterizes the exhibit, and the document speaks for itself.
Well,
Overruled. You may ask your question.
sir, does she tell you in that text message that she's drank too much and has to get a hotel?
She doesn't tell me that directly. No.
Then, sir, could you explain to the court why you would swear under oath that you have a text message that she had too much to drink and they were getting a hotel for the night?
Because too much to drink is any drink when driving with my children.
So you don't think, just so that I understand, you think that this sworn affidavit is an accurate reflection of that text message that you received from her?
In my opinion, yes.
And if the court appoints you as the managing conservator, those are the kind of decisions we can expect in the future? Is that what you're telling us?
If you're expecting no drinking and driving with children, then yes.
Objection, non-responsive.
I'm clarifying to what you're expecting.
Sir, I'm expecting honesty. You think maybe you could share some of that?
Objection, argumentative.
I'll pass the witness. Yes, sir, I apologize.
Mr. Koo, I only have one question for you. When you
Yes.
applied for that protective order and we walked up to the judge, you were there with me that day. You remember that?
Yes.
And when you went to testify to the judge as to the reasons for the kickout order asking her to be excluded from the marital residence, do you recall that?
Yes.
Do you recall presenting that text message to the judge for him to understand and consider all of that?
I'm going to object. It assumes facts not in evidence. It's leading that those two.
Did you present anything to the judge?
In addition, Judge,
What?
I'd ask for under the best evidence rule, I think they would need the transcript if they're going to talk about some hearing that they didn't give my client notice of and she wasn't even a participant in.
My client's been alleged to have misconstrued something to the court, which was presented to the judge prior to the protective order.
Well,
Objections overruled.
Mr. Koo, do you remember providing that text message to the judge?
Yes.
How do you think you in any way bamboozled the court with your statement?
I don't feel like I did that at all. I feel like I was just trying to be a protective father.
And in the future, when the court is not involved anymore and the attorneys aren't there anymore, and there's no pulling Mr. Honey away from the craps table at the Nugget, how are you two going to communicate if Natalie is the primary conservator of the children?
I don't have an answer for that. I don't know. I don't
Pass
know.
the witness, Your Honor.
I have no
Mr.
further
Mahoney,
questions.
anything
Witness,
further?
Judge. No, sir, not at this witness at this time.
Mr. LaFever, any additional witnesses you'd like to call?
No, Your Honor, since we stipulated to submitting our fees, we'll just get those out.
And Mr. Mahoney, I'm sorry, respondent rest?
We rest, Your
Ms.
Honor.
LaFever?
Yes.
Any rebuttal evidence, Mr. Mahoney?
Judge, I only want to offer P33, which I think was stipulated to. That's my child support calculation without going through the numbers in rebuttal to the testimony that he's presented. I would just offer P33.
I mean, I won't stipulate as to the numbers, but.
Right.
I understand. I mean, I'm not.
And yeah, other than that.
All right, so P33 is admitted. Anything further, Mr. Mahoney, from your side?
No, sir, Judge, other than submitting some invoices, but whenever you would like them. If you want us to do that
And
now, we
Ms.
can.
LaFever,
Or if you-
any?
Sorry.
Well, here's my thoughts. I want to finish this case, and I know everybody does, especially the parties. I do have a daughter that has her first playoff soccer game at 5:30, so I need to get out of here at 5 today to get there when the game starts. But y'all are going to have closing arguments, and so my thought is, if y'all want to submit, if you have your invoices available and you want to submit those now, and each side have 10 minutes for closing, we can do that. If you want to have 45 minutes or an hour tomorrow and submit your statements tonight or by tomorrow morning, then I can give you all closings and give you a ruling tomorrow. I'll leave it to both lawyers, but I can't work after 5 today.
Your Honor, I don't know that my closing is going to take all of that long. I mean, we've just beaten the horse for 3 days. I don't think you want to hear us say it any longer.
If we want to do it in 10 minutes, I can do it in 10 minutes. I know, don't laugh, Minnie.
But the only thing is I'm going to need to see those lawyers' bills, their statements, before I give you my ruling. So what I can do is, I hate taking things under advisement, but I can take it under advisement, or I can have y'all report tomorrow and give you my ruling on Zoom.
I would like to do it that way, Judge.
That's fine by me.
I don't need 45 minutes, but I would still like to do it that way if that's okay with the court.
All right, what time works for y'all tomorrow?
I moved all my stuff, so whatever you need us, whatever works for Miss Lefevre.
Can you do 11 a.m.?
Yeah, I can do 11 a.m. I'll reschedule that appointment.
No, you don't need to reschedule.
No,
something
it's
if another
fine.
time
It's
works
just
better.
it was just a client preparation for a hearing next week, so I can move him later in the day.
Well, I think it'll probably take 10 minutes. So you might just delay that meeting for 10 minutes. I don't think my ruling is going to take a whole lot of time. So I'm going to let y'all give your closings now, and then I'll review the exhibits that y'all present me by tomorrow morning, and then we'll give our ruling at 11 o'clock.
Yes, sir.
Okay. All right. Mr. Mahoney, would you like to start your closing?
I would, Judge. I'd just like to break it up 5 and 5, if that's okay. May I proceed?
Okay. You may.
Judge, I think the evidence has been clear. Although, while I think that Ms. Q has testified that she admitted she's made some mistakes. She hasn't been perfect. She's done what she can do. And I think that the evidence is clear that she's been there for the children. I don't know why Mr. Q would think that in all of this evidence that he would need to be appointed as the sole managing conservator of the children. I wondered that pretty extensively until yesterday when he testified that he wanted to move to Austin. So that was kind of the first time. And I think that his holding that and mentioning it for the first time after his case, or when he started his case in chief, is indicative of the lack of respect that Mr. Q has for Ms. Q's role in the lives of these children. I think that Mr. Q has expressed some concerns about the children. And I think that if he would take a step back and look at some of his actions, he would see that a lot of these concerns for the children stem from his actions as well. And I think that these folks obviously need to learn to communicate better. But at the same time, I think that the evidence is clear if the court looks at what's been presented, that there are times when Ms. Q has communicated with Mr. Q. And to say, well, she communicated, but she didn't say what she should have said, or she didn't say what I wanted her to say, is kind of a misnomer when you look at the text messages from Mr. Q and he just ignores her. Now, to his credit, he always had an excuse. It was always somebody else's fault. I think that if you look at those emails, Judge, during the winter storm, if you look at those emails, he talks about how dangerous it is and how important this situation is until he gets the kids. And then once he gets possession of the kids, he's gone. And to sit there and tell you, like he did both Tuesday and Wednesday, that he's been the one that communicates. He's been the one that puts the kids first. Judge, he wouldn't even tell her whether or not he had electricity. He wouldn't tell her whether or not he had water. That wasn't a trick question. that wasn't, one of the things that was very interesting to me is that I didn't even get to ask Mr. Q about playing games before he volunteered the term games. Who's playing games? All he had to say was, the power's back on at my place, we're good. Really, all he had to say was yes, but he couldn't say it. He had to play this roundabout. This is the way it is. Oh, I'll take care of their needs, and completely refuse to communicate with the mother of his children. I think that his lack of remorse for his sister taking the ex parte protective order to the neighbors, what was she trying to accomplish? And let's say that he acknowledges she should have never done that. He never acted like, never even said he had a problem with it. He knew she did it. He knew that it wasn't right, but he never will admit that what happened and what was done was not right. He has zero respect for this lady. And if we sit here for 3 days and we see that lack of respect just in the courtroom, the court can only imagine what that lack of respect is like when we're not around. And if you think those boys don't see it, absolutely they see that lack of respect for their mother. And as the kids get older, I think the court is aware. You've done this longer than me, and you have seen this type of behavior and what it does to the children and what it does to the development and the relationship between the mother and the children. I would just ask that the court, this is not a sole managing conservatorship case. Absolutely not. Nowhere close. One incident that you can watch the video, I don't see any type of assault, but one incident, and he wants to claim a pattern of family violence, and now he needs to be the sole managing conservator. This is a domicile restriction case, joint managing conservators.
That's 5 minutes.
Yes, sir. And with Ms. Q being the primary,
Let's go to Ms. Lefevre, and then I'm going to give you your 5.
Yes, sir.
Ms. Lefevre.
Sorry.
The court remembers how close this temporary orders hearing was. It was another 3-day, almost full out knockdown, drag out trial. And you warned Ms. Koo regarding the alcohol and that if she violated the temporary injunctions, that you were going to flip custody. It was that close. Why? Because these are 2 involved parents, but someone was making bad decisions. Ms. Koo has been extremely unforthcoming through the entire course of this trial, of this proceeding. From January, she did not produce documents. She failed to disclose her income. She refused to tell both Mr. Koo and then the court who the caregivers of the children are. Even after he asked for the safety of the kids, she would not disclose it. Yet she wants to try and cling to 2 things that she misconstrues. The ICE incident as Mr. Koo being uncommunicative, where she refused for months to communicate with him about therapy, about where the children are. But when it's convenient, then it's Mr. Koo's fault. And why is that? That is because Ms. Koo is incapable of owning her own actions and being responsible for what she has done to herself and her family. If he had not been recording, however potentially damaging it could have been for the children for him to have been recording, had he not been recording the night that she got arrested, Mr. Koo was going to jail. It was so bad and to such a point that he had to get to that and record in front of his children to prove that she was lying. And she's lied throughout this trial. She has lied throughout this court case. She lied to the police about what was going on in the house and tried to have him arrested. If this person is willing to lie to you and to lie to the police, she's going to continue to lie to my clients and the kids. If we're concerned about the well-being of the children, then that's what we need to be concerned about. Someone who's drinking, who's abusive, who locks her son out, who tells her daughter that she's not going to write her love notes anymore and leaves her crying? You've heard from the children, and we ask that you take into consideration what the children have had to say. We ask that you take into consideration the evidence of the violence that have happened prior to the filing of this divorce. And that is why Mr. Koo filed for sole managing conservatorship in 2019, not 3 weeks ago when he found out he possibly needed to move to Austin, but in 2019. And if anything, the last 15 months have just proven that Ms. Koo is incapable of co-parenting with Mr. Koo. And once lawyers in the court are out of this, she is going to probably be even less communicative. Mr. Koo is a very involved parent, and maybe he's made some mistakes. But if he's told her that the kids will be provided for, and he's done it twice, she can't take that as enough, because she continues to control, she continues to manipulate. And that has been the history of this marriage. You've heard about the emotional abuse. You've heard about how it used to make Mr. Koo feel. This is the same person who's now trying to do the same thing to her own kids, to teach them that love is conditional. They keep clinging to the winter storm because they have no other bad things to say about my client. There is documented evidence of her lies. There is documented evidence of her abuse, and there is documented evidence of her alcoholism. They are clinging to one weekend of text messages where attorneys even intervened, and she still called the police. How is that the healthy environment for these children to be raised? Mr. Koo is asking to be sole managing conservator for that reason. Mr. Koo is asking for a disproportionate division of the estate because he has been exclusively supporting this estate, exclusively paying for the bankruptcy, exclusively paying for the mortgages he can, exclusively paying for child support, while Ms. Koo has been spending money that she cannot account for. Months that she cannot account for. Mr. Koo is asking to be reimbursed for that money that she cannot account for because he is so in the hole and he has made so much less money than he did in the past that he is going to be forever climbing out of it. The court, he is asking the court to equitably divide the estate and to disequitably divide based on her behavior, her abuse, her alcoholism, her fault in the breakup of the marriage, her fault and these attorney's fees continue to be racked up as she continued to not supplement discovery, and that there is even more waste out there that my client will never be able to actually prove because he doesn't have bank statements or credit card statements. So we ask the court to do what we believe to be best for the children and award my client sole managing conservatorship, or at least to be the primary conservator with the exclusive right to designate the primary residence of the children.
Thank you, Mr. Lefevre. Mr. Mahoney, you may complete your closing.
Judge, and thank you, Ms. Lefevre. And you know, it's been a pleasure. And Judge, thank you for giving us an opportunity and giving us a little leeway. I know sometimes Ms. Lefevre gets a little over the top, and I'm sorry about that, but I'm sure she may. But regardless of all of that, Judge, she and I, we were at a different trial, and that's part of the issue. And if you take away the evidence, if you take away the testimony and just look at the exhibits, just look at what's been presented. Here's a guy who was video recording to protect himself. And let's assume that that's true. If he understood he needed to video record to protect himself, you don't think he knew he needed to bring the text messages that he spoke of that prove all of this stuff that he said? You don't think he knew that he needed to bring evidence? This is the same guy that recorded everything, according to him, because he was protecting himself. But you won't see any proof other than his testimony of what she allegedly told the police that night. We didn't hear from any of the police officers. You won't see any proof other than his testimony of what allegedly she says to the children. Now, I wasn't around for the child interview. I know Ms. Lefevre wasn't either, and I don't know what the children said. But I know this: if he shows the lack of respect to their mother around them that he's shown here this week, there's no telling what these kids said. But I think the court can see through that. One of the most telling things happened just about 20 minutes ago. And I asked for exhibits, and so they brought them to me, and they brought this exhibit of her text message where she was allegedly drinking and driving with the kids. And first off, that text message clearly doesn't say I've drank too much. In addition, if you look at that text message, if she had drank a little, then she stays at a hotel. Isn't that what he would want her to do? Isn't that what he's asking for, to keep his kids safe? But instead, he takes that text message and represents to this court that she texted him and said she had drank too much. But then, after the question came about the text message, then Ms. Lefevre asked him, well, because you can't be around her, you can't gather evidence of her drinking and violating the injunction. Well, if that's the case, Judge, and I have no doubt that's probably the case. Well, how many times has he told this court that she's violated the injunction? And then at the end of the trial, he admits that he didn't know if she violated the injunction because he can't be around her? Well, then that's what he should have said. He shouldn't say she's violating the injunction and then come into the trial and say, oh, well, I can't prove she's violating the injunction because I can't be around her. Well, then don't tell the judge that she's violating it. If you don't know, say you don't know. But speaking of don't know, I thank him for bringing those 2019 check stubs, because if you look at the 2019 check stubs, you'll see that rate of pay. And then if you look at the 2020 check stubs, you'll see the rate of pay, and it got an increase. Then if you look at the 2021 check stubs, you'll see the rate of pay, and he got an increase. Judge, if you believe that he didn't know that his pay didn't increase, then I've missed the boat, because this is a man that gets the same increase. And then he tells me when I'm asking him questions, oh, it may have been a cost of living increase. Well, yeah, he knows that because he gets it every year. But he started this trial off telling you that his rate of pay was the same. And then they're going to come in here and complain about the pro se client didn't supplement discovery. But oh, by the way, we didn't bring any 2021 check stubs until day 2. Come on, man. If you want to talk about discovery, then you got to come in with clean hands. You can't come in day 2 with new documents. You came in day 3 with new documents. So again, even if you boil away the testimony, and I don't think you're going to find any actual proof that Miss Q misrepresented anything. But you will see evidence, documentary evidence after documentary evidence after documentary evidence where Mr. Q has misrepresented things to the court, to the doctors, to the school. He's misrepresented things over and over and over, and then comes in and says, well, I should be the sole managing conservator because she won't talk to me. Look at the email. Look at the email. She didn't want him at the hospital. And if that's wrong, that's wrong. But if he has a problem with that, then why did he come in today or yesterday and ask for an injunction against her being within 100 feet of him? I thought he wanted them to communicate. So it was wrong when she did it, but now he wants to be able to do it himself. Judge, the evidence is clear. You have all the exhibits. I know you'll do the right thing, and I appreciate your time. And I'm sorry, many of Ms. Lefevre talked too fast. Thank you.
Thank you. Thank you, Mr. Mahoney. I want to thank both lawyers. It's always a pleasure having each of you in my courtroom. What we'll do is if y'all will send Minnie that exhibit, I'll look at those tomorrow morning, and I'll make sure that I go through all the exhibits, and I will give you all my ruling tomorrow morning at 11 o'clock. With that, we're going off the record.
Thank you,
Your
Judge.
Honor, just a quick question. Do you want a summary? We already submitted some of our billing statements, but they're obviously kind of voluminous. Do you want just like a Excel summary? It would be basically the same thing. It would just be not all broken out. my system can generate an
Whatever
icon.
y'all have,
Okay, I was just gonna do a
whatever y'all
summary.
have is fine. Summary,
Okay, all right, then we'll do that.
that's better for me because it's easier to digest.